NACDL is the association of the nation's criminal defense bar.
Good afternoon. We're going to talk a little bit about the practicalities of bail hearings, apart from the law and apart from dealing with judges, about how you can be the best advocate during these bail hearings. We want to encourage that anyone can do it. It takes a little bit of practice and a little bit of getting used to being in the jail, but anyone can do it, and it can be very satisfying.
It's a lot of fun.
Jen, do you find it fun?
Yes, I actually find it very rewarding.
I think part of the reward for me is that it's instant. You know, it's not like doing appellate work where 3 years later, I finally won my case. You know, you might get someone help right then.
And many times the clients are so appreciative, and they've started crying before, and especially someone who's been through the system before in Harris County. So number one, they're shocked when they meet us because they say things like, you all have never been here before, right?
Or they say, am I going before the TV judge?
Constantly.
But
also many of them will say, in fact, I constantly hear, I've never received a personal bond. Never received a personal bond. And I do have this story where I was interviewing a young man, and I don't remember what he was charged with. It was a felony, though, but it was a low-level felony. And he was tired, and he said, you know, I'm not trying to be rude or disrespectful, but I don't want to waste your time. I don't want to waste my time. I've never gotten a personal bond before. So, you know, like, I'm going to go lay down. And so I tell him, I say, well, I understand that you've never gotten a personal bond before, but have you ever come in here and talked to an assistant public defender before? And he said, no. And I said, look, you can't get what you don't ask for. So maybe you won't get a personal bond, but at least let me ask, because you might get one. And he actually started laughing, and he was like, fine, silly woman, go ahead.
You're like, okay, miss, you can try.
Yeah, he really thought it was like, yeah, you're cute, go ahead, you know, whatever. And so we went to the bail hearing, and he was approved for a personal bond. And when we were walking off, I just kind of said, you know, quietly, I was like, I told you, whatever. And he actually started laughing, and he was like, thank you, miss, you know, whatever. Like, and it just like, it really warmed my heart, because at the beginning he was like, you know, I'm not going to get one, so let's not waste anybody's time.
They feel like they've won something sometimes.
They have. They've won their freedom.
Yeah. I mean, they really, it's like validating as a person to some of these folks, you know, because you get up there and you tell like a little snippet of their life story and whatever, you know, hardships they're going through or whatever good things they're doing in their lives that they need to get home to. And, you know, they really feel like they've won a prize. Like it's validating.
I think they also like when we don't do, I mean, you can't do it often and for every case, but when we bring up to the judge, like problems with their case, like, hey, judge, you know, it says the complaining witness did not feel pain and does not want to press charges. Or, you know, judge, I think under Terry v. Ohio, there's an issue with this search or whatever. And even though it may not go anywhere in terms of probable cause or what it may be, some of the hearing officers do take that in consideration. And I've had hearing officers initially say no personal bond, and then when we point something out, you know, in the probable cause summary, they've changed it to a personal bond. And it just gives the client a sense that you're actually trying to fight for them a little bit.
And that you've listened to them, because they always want to come, you know, talk about how they're not guilty or whatever the police did wrong. But you have to be super careful about that, because if you start pointing out that the search was illegal and then the trial attorney, you know, decides to do a motion to suppress later, then you've put the state on notice possibly about what the exact legal issues are going to be. And so then they have the opportunity to, you know,
shore up the witness.
I don't think about that, actually.
Yeah,
I don't think about that issue.
I know that happens. I see them writing notes, so, but, you know.
Okay, preparation. What documents do we need and what do we need to do to prepare for these bail hearings?
Okay, well, so number one, you have to get the PSA. Right. So you have certain documents that you need in order to perform the bail hearing, and so we get a stack of these risk assessment reports, and we have to. We get a stack of risk assessment reports from pretrial services, and there is a lot of sorting of paperwork that we're currently doing, and everybody's like, it's 2018. Why do we have all of this paper? And it seems like a big waste of time, but it's essential part of the job. And so you get a big stack. We call it the dump, and they are all mixed up out of order, and we bring it over to our area where we have alphabetized files, and we file all of these PSAs by last name alphabetically, so that then when we get the docket sheet of all of the clients that we need to interview for the next docket and all of the cases we need to prepare for, if we see, okay, first on the docket is Mr. Arturo, then we go to the A's, we pull out his PSA, and we have it there and ready. There's also some other documents that we can assemble that are a little bit more optional, such as Jen is very good about the paperwork.
In fact, they make fun of me for all my paperwork that I collect.
She makes big old stacks and packets for everybody.
Well, I guess we probably should say that that the most important thing is you have to interview the defendant. That's like most important, right? So when we go interview the defendant, we may not have the PSA yet.
And that's okay. We don't need the PSA. Some people feel like they need the PSA in front of them to see, what bond to expect and things like that. And so they focus too much on the paperwork, right? And then they delay the interviews, and things tend to go awry sometimes. So we don't need the PSA.
But so when we go interview them, we do have a form that we use, an interview sheet that basically where we collect information from the defendant, like pretrial, but it's actually in a much more condensed form. The other thing is that we often don't have a lot of time with defendants. We may have an hour to interview 25 people for the next docket. And so if possible, when we're interviewing the defendant, at least I know that I try to look up, at least on the Harris County District Clerk's website, their criminal history, so that I see whether they have any pending cases, either on bond or if they're on probation. I can get a snapshot of what their background in Harris County looks like. Whether, sometimes you'll see they have nothing, and sometimes you will see, and you're scrolling down because it's pages and pages. If the person has been arrested on a warrant, I try to print out the warrant right then so that I can know the facts and circumstances of the case. Also, is this something where the allegation is from 3 years ago and the person has just gotten arrested on it, and because they haven't had any contact with law enforcement in that time? Or is this a warrant that was issued yesterday and they were arrested last night and the allegation is from 2 days ago?
Right. So like while you're usually like when I introduce myself to them, I usually tell them, I just need to ask you a few questions so that I have information to argue to the judge in order to try to get your bond set as low as possible. At the same time, I'm going to be looking up your case on the computer to try to find out some information. So, I'm not trying to be rude. I'm focusing on your case as I'm looking at the computer screen. I am listening to you. So you try to do both things at once, because you really only have like 5-10 minutes tops to focus on that one case and compile all of your information.
We also do have access to the pretrial interview, although it may not be complete at that time. When we're interviewing the defendant, we have access to their financial affidavit, right?
That's right.
Sarah's very good about printing out the financial affidavit. I am not.
It's important on the misdemeanors now.
Well, and it's important too, because if the client tells you when you ask how much money they have for bail, and I've had the case where they're like, I only have $50, but in the financial information to pretrial services, there might be something different. So it's good to know that information and say, well, what about what you told pretrial services? And it's not they're trying to deceive you. I think they're tired, they're confused, and they're not exactly sure what you're asking. So I think having that information is very important, because I know it's burned me where the judges will say, well, Miss Maselli, it says such and such on their financial form, and if I haven't had time to get it, I'm like, I can only go with what I know, Judge.
Oh, and I agree. I'm not saying it's good that I'm not good at getting it, but I agree that it's important. But I think that brings us to the point, though, that the interviewer, how the person interviews the client, the questions, the way they're phrased, the way it's explained, really impacts the type of information that is obtained from the defendant. As you mentioned, there's a lot of things that go into it. They could be tired, they're hungry, they're cold, they're hot, they're sick, they may be injured, they need their medication for whatever reason, but they may answer a question one way with the pretrial interviewer and answer a question a different way with you, but it's not, as you mentioned, like they're trying to deceive. They just understood the question differently. So I do agree that it's important. I'm a big believer that like information is power. So the more information you have pertaining to someone, you know, the affidavit, the interview, the pretrial report, the information we gather. I also try to get the DIMS summary, which is the sworn statement from the police officer, because I do like to know, you know, the circumstances of their case. I try to get as much as possible. And then, of course, the PSA, because we do use the PSA. Even if you don't have it when you're interviewing the individual, you need it, and it is a must during the bail presentation.
Yeah, the PSA and the interview are really absolute musts.
And
the other stuff is good to have, but if you don't have it, you can still proceed with the docket.
And we have an interview form. Here's just a sample of an older one. And so there's certain information you want to know: how long they lived in Harris County, if it's a family violence case, do they live with the alleged complainant? What are the other things that are like paramount that you both?
Well, actually, but piggybacking on that, if it's a family violence case, I always want to ask them, okay, the judge may issue I want to explain the protective order that the judge may issue and the ramifications and consequences of that, and make sure, okay, so if the judge does issue this protective order that says you cannot go within 200 feet of your home address, where do you plan to stay? I mean, that's really, really important.
The judge will want to know that before they set bond, because that's one of the few times when the judge will actually look at you in court and say, you know, and ask you a question about the case. Does your client have another place to stay if I issue this protective order? Because if not, guess what? Your client can stay in jail. Like, that's how they're looking at it. So they want to see what the chances are that your client's going to obey their order.
I think information related to kids, especially if someone is a single parent and they have children that, you know, are under 18 years of age, if they have custody of them. And then I often ask them, well, where are your children now? Well, they're with my mom, but my mom is 73. And, you know, I have 3 children between the ages of 2 and 7. And so my mom can keep them for a couple of days, but beyond that, she's not going to be able to keep them.
I've even used that question. People have been very concerned about their pets. I live alone. My dog is in the house, and I will use that because I think that people recognize pets are like kids in many ways, maybe better than some kids. I'm sorry. And but, you know, those sort of things, I think it's like you say, knowledge is power, and imparting that and sharing it with the court. This person has responsibilities. He works. He's got a pet. He's got to go home.
Right. And there's a lot of things that you don't think about until you actually start talking to them, such as someone may not have children or pets, but maybe they go to their grandmother's house on Mondays, Wednesdays, and Fridays to take them to their dialysis appointment and to cook their dinner for them. Or of course, when people have jobs, that's always like the big thing if they currently have a job. And people are very, very fearful about losing their job, especially if they have a criminal record. And I've had people say to me, like, it was hard to get this job. And like, I need to get out. I have to be at work tomorrow. I've actually had clients ask me if they can call into their job. They'll say, can I please, will you call my job for me? Because if I'm a no show, no call, that's grounds for automatic termination, and I say, well, do you want me to tell them where you're at? And then they kind of like, well, whatever. And, I think anything that shows their ties to the community and their responsibilities,
And if it's young people, one of the questions I always like to ask is, even if they're not in high school anymore, if they're just out of high school, what activities did you participate in? I mean, I've argued like, Judge, this person was in the marching band and played the bassoon. I mean, this is a kid. He got a personal bond. Thank you very
How
much.
is a bassoon player going to be a danger to the community?
To me,
prima facie evidence, he is not a danger to the community.
it personalizes that person. I try and use those
Right.
questions that what makes this person unique? Why is he worth getting out and being saved?
It's like a miniature punishment mitigation case is what it is. It's like a tiny little sentencing hearing before you've even been convicted of anything. And like that tends to be how some of the judges think about it. Like they really feel like when they set that bond, they are, meting out the person's punishment.
Right. One question that our coworker Emma always ask the clients, which I now incorporate at the very end, she says, is there anything I didn't ask you that you think is important for the court to know about you? As to like why you need to get out, or, something about you that you think the court should know. And when I heard her ask that question, I thought that's a really good question, because sometimes, I'll speak for me, sometimes it gets overwhelming a little bit, like the number of people that we have to interview in a day and trying to get ready for docket and just, racing back and forth. We've talked about sometimes we go whole shifts without eating and whatever, that sometimes you get kind of I get on autopilot. And it's important to step back and not just follow the form. But that brings me to another point. I think you mentioned the form that's currently up might be an old form. Sarah has actually gone through and made changes to forms over time, which actually shows how things have evolved, because during the course of the process where we've learned like, hey, we need to make sure we ask this question, or maybe something that we asked before, we realize that's not really as important, but here's something that we weren't considering in the past that maybe we should.
Maybe I should add the Emma question on, what else do you want the court
That's
to know?
good.
Maybe I should add
But
it.
it's a great question, and sometimes they say like, no, I think you've got it all, and sometimes, and I always have to say, not about the facts of your case,
About you and your life.
And sometimes for me, if they're not that talkative or they're feeling, nervous, I go back to old questions I used when I used to do mitigation. Something like, just to break the ice, like, who taught you to tie your shoelaces?
Oh.
And it's like, oh, well, that was my cousin Joan. And so then we just start a conversation, and it sort of breaks the ice when I've had people who are a little like, they don't trust me. They're not sure because it's so fast. So, who taught you to ride a bike? And so those sort of questions, and I don't use them often, but I found they're helpful in breaking the ice and maybe getting someone to just start talking and feel less scared and less distrustful.
I would like to see some samples of those questions.
I have a bunch of them.
Well, a question that I found kind of gets people smiling always is if it's someone that I always ask people if they have children or whatever, and they'll say, oh, I do, but they're all grown. And so then I ask them, oh, well, do you have any grandchildren? And they tell me how many. And then I always ask the men, and this gets them smiling and laughing and relaxes them. I say, what do your grandkids call you? And then they're like, Paw. I'm like, okay, Paw, or like,
That's great.
it always makes them like literally start smiling because they're, obviously they're thinking about their grandchildren, which who doesn't love their grandchildren, and then thinking about like what their grandkids call them, and it helps them. It really always makes them laugh.
And I think our next slide is interview tips. I think we've come, and I know you both do it a lot more than I do, but people who may have some special circumstances. And I know, like, for example, I've had people who I think might still be under the influence of maybe some substance.
Allegedly.
Yes, allegedly, or maybe they didn't get their medicine and that's why they feel a bit light. But how do you deal with somebody who really is having some difficulty communicating? Like, what do you do, Sarah?
Well, one thing that I learned from Jen was that I noticed that, like, you always ask, "Hi, Mr. So-and-so, how are you doing?" Or "How are you today?" Which seems like a stupid question because they're in jail, but the response, whatever response they give you, serves as like a gauge to see what level they're on. Because some people give you the polite response like, "I'm good, how are you?" And then you know that you can just have like this customer servicey, professional, like conversation, and they're gonna be very like with it or whatever. But then other people, they're like bad. And then you can sort of get down on that level and be like, "Oh, I'm so sorry, sir. Let's see if I can do anything to help you."
Right.
So it serves as an immediate taking the temperature of that person.
Some of them will say like, "Well, I could be better," and I'm like, "I guess so." Couldn't
Right, I chuckle.
Yeah,
Yes.
we laugh. I bet you could be, right?
I guess so. That was a stupid question for me to ask you. And then you go through that thing.
Yeah. So, but also it depends because some people are really angry, like really angry, especially if they feel that they've been unfairly arrested. And so I have found that, which sounds like it's common sense, but I have found that lowering my voice and talking to them in like a soothing voice and being like, more sympathetic to them and kind of like, I understand and I'm really sorry, really kind of being empathetic.
Expression of sympathy a little bit goes a long way. Yeah.
Not fake, but I know that, and people may not know this, but we currently, where we interview, the majority of our interviews are in a room that also has pretrial officers, and the pretrial officers are doing their interview as well. And sometimes when the person is finished with pretrial will bring us their information so we can interview them next. And the pretrial officer may say something like, they're really angry or they're not talkative or,
Good
it's
luck
hard.
with this person.
Yeah, good luck and whatever. And, but so if I know that in advance, though, I often may change my tone, may try to talk to them differently. And it sometimes will help just being more, and I may think in my head, okay, I'm going to have to spend a little more time with this person, kind of be a little more conversational,
But then a lot of the time it turns out to be nothing and they're totally fine with us.
And that is true sometimes. And then on the other end of it is sometimes a person just doesn't want to talk to you and they're not going to talk to you. And even when we try to explain, well, like, can we just try to help you? And they will literally walk off, just walk off.
But then in court, when they're before the judge and you have the assistance of the public defender, do you want them? And they're like, yes. I was like, what? They told me no.
Right.
Judge, I'm going to need to hold them to the end of the docket. I haven't spoken to them yet.
Right.
One thing that I thought was the worst thing I learned about having to do this for me was having to lie, in the sense, like, I've had women weeping and saying, is it going to be okay? And I'm like, yes. Because at first I'd be like, I don't know this. And then they just start. And I thought, this is not the time for all truth, because maybe it'll be okay. It looks really bad right now, but I'm like, it's going to be fine. Don't worry. I hold him by the shoulders. I said, it's going to be fine. And that has stayed with me for so long, having to do that and just really comfort someone and not give the full honest truth. Like, hey, this could go off the rails. You're in this country, you've been deported before, and you have 5 children and one is still breastfeeding, and it's gonna be fine.
Right.
It's gonna be fine.
That is, yeah, it's really hard when you have to give them bad news. And so, like, you know, so you have to prepare them for all of these potential bad things that are going to happen. And sometimes it gets them really upset, and it, like, you know, it ends up making the interview take a lot longer, and it takes a lot of client control. And one thing that I have found is, like, so for instance, like, one of the first things that you tend to talk about with people who are there for family violence is, what if there is a protective order and you can't go back to your home? Well, they freak out, and they're like, well, no, because of this and that. And so then I am always like, I don't know if this is going to happen. They may not even do it, but I just want to make sure we're prepared in case it does. And sir, you know, you may get the personal bond. You're probably going to get the personal bond. But just in case you don't, I want to make sure you're prepared. So who do you be thinking about a backup plan. Who do you think you might be able to call that could go to the bondsman for you? Just be thinking about it just in case. Part of my job is to prepare you in case things don't go exactly right. And also, like, people who I know are going to probably be no bonded or set at really high bonds or things like that, or when they're not eligible for personal bond. Some of them, I don't give them that bad news. Like, during the interview, I have started, like, and this is what Wade does, is we do it during the speech. Like, there's certain cases, you guys, where the judge in this court may not be able to set a bond today. Those are cases where you're already on felony probation and you've been arrested for another felony. You may not be able to get a bond today. See, whereas if you had that conversation, like, during the interview, then they would have gotten all upset, and it would have been this whole thing where you had to try to make them feel better.
Well, and I disagree. I mean, I
Yeah.
save the bad news for, if possible, till the end.
Mm-hmm.
I get through the interview, because you're right. If, like,
Yeah.
that the protective order thing, or the, where you have at least 2 prior TDC convictions and this was what may happen, I save it to the end. I get through. And they'll be asking me questions, and I'm like, yes, sir, but let me just get through this, and then we'll talk about those things, right?
I'll answer all your questions as soon as we finish with these. Yeah.
But I also tell them, because I think one of the biggest benefits of us being there during these bail hearings is giving them information, preparing them for what's going to happen. I actually was appalled once I got into the bail hearings and I realized how they had actually been conducted in the past. And when they said, oh, there was 60 defendants on a docket, and it would take 30 minutes, because it was just like, and they were just in there in the big room by themselves with deputies, because the judge wasn't in there, the prosecutor wasn't in there, the clerk wasn't in there. It was literally just the defendants and, deputies. So it's pretty,
with TV.
It's pretty appalling, right? So I think telling them what's going to happen, telling them what to expect, explaining basic stuff. They don't understand what probable cause means. And so I try to explain to them that it's a very low standard. It doesn't mean that you're guilty. Doesn't mean you have to plead guilty. Doesn't mean the state has enough evidence to prove you guilty. And I do this little thing, I'm like, it's like this far off the ground, and they're looking, because they think it's like, we're going to go in and we're going to fight the case right now, explaining to them about what their bail might be, why it might be. And I explain to them, me personally, I don't say the judge can't set bail, because that's not true. They can set bail on everything, I think, except capital murder, right? So even if they're a true habitual, even if they're on deferred, even if they're on parole, they are actually entitled to bail. So I personally tell them, and I tell them individually, however, especially if they're charged with a felony, and I ask them how many times they've been to TDC and those type of things. And I explain to them, the state is probably going to ask the judge to set you at 0, and this is why, and I'm going to object, but the judge is more than likely still going to set you at 0. And so this is what you need to do. You know, when you meet with your attorney, whether it's before you go to court or in court, ask your attorney to approach the judge in your court and set bail. You know, and I try to explain all those things, and they're upset, but at least they understand, you know, what may happen and how to address it. You
It
know,
depends on the person. When it's a close case like that, when it's, you know, there's some cases where it is just absolutely completely inappropriate for them to be no bonded, where it's old priors, where it's something new that's not violent, and I will go all out on the argument about do not no bond this person. It needs to be set, and a lot of the times they will set a bond, depending on who the judge is on those cases. But most of the time, if they're habitual or if they, you know, they're here on an ag rob and they're on probation for another ag rob, you know, they're just not going to have a bond set.
I mean, I understand that, but I don't tell them the judge can't set them because the judge can. They're just not going to. You know, I mean, they can. They're just
they can
not.
also give a personal bond on every single case.
But you're going on a separate issue. I'm saying in terms of.
Well, to listen to the judges, they can't set a bond.
So, you know, which is when I point out, that the Texas Constitution says may, not shall, right? And only if these things happen. Right. You know, the state files a motion, they have a hearing within 7 days, they prove it by substantial evidence, the judge signs an order. And even then, judge, they can only hold them at 0 for 60 days. And then they're entitled to bail.
And regardless, only the district court.
Yeah, only
Can't deny bail.
But
so there's multiple reasons.
But, you know, so those are some things, as I say bad news to the end, but I do talk to the person about it. Sometimes people have mental health issues and they don't understand.
Right.
And if they don't understand what's happening, you know, I'll ask them questions. And, you know, there have been times where I've gone to the deputies, like this person, like they're not competent. Such as when I had a girl kept telling me she was 14. And I said, you're 14? And she's like, I'm 14. I'm like, you're 14? And, you know, we're going back and forth because I'm in shock because obviously a juvenile is not supposed to be in there. And then she tells me she's 14 in cat years, you know. So, no,
So
not
2?
I don't know how old that is, but she didn't understand. And, you know, when I asked who she lived with, she said with everyone. And it was very tiring, you know, like she just wasn't up for it. And so if they have a issue where it does not appear that they understand, I let the deputy know to say like, hey, I think this person needs to go on to like the mental health unit, you know.
I've had some issues where I think people are physically sick. It could be like diabetes. They haven't had their insulin. Mm-hmm. And I have had I've had no success getting anyone to do anything. The deputies? The deputies. And they're like, well, you know, after court, they'll see someone. But I find that really difficult because I can tell they're ill. They're in pain. They're in pain. Yeah. And something like diabetes, they can't comprehend because it's a brain cloud. And so how do you deal with that? I've had no success getting anyone any help ever.
Oh, like if you insist on to the deputies, like this person is in really bad shape for whatever reason. I mean, if
they
it's
will
just
do
like, something. I have them take them straight out of 140 to medical. I also have started having. I mean, you have to have something good to say as far as
right.
Why it's stat.
I mean, it's not.
They should be med stat. You know, it's urgent. Also, another thing is when I've already done the interview for the person and they're sick and I'm asking for them to go straight to medical instead of coming to court, I have them sign a thing saying I consent to the public defender representing me in PC court.
I do that as well. Okay. But I also tell them, because sometimes they're like, no, I can make it to PC court, but you can tell like the color is, right. And I agree. There's a lot with people who are diabetic, yes. And like their color will drain from their face. Like they're shaking. They don't look well. And I tell them like, I'm going to go tell a deputy, but when the deputy, if one comes in before I get back, tell them that you are sick and that you need to go to medical now. I mean, you know, like they need to tell them, not just like I'm thirsty or like, right. Like I am sick, and because if they're not well, I mean, it's not beneficial to them, or anyone. But I do agree with Sarah. If I'm interviewing someone and I'm thinking this person may not make it to probable cause court, I write down at the bottom of my interview sheet, like, I, Bob Smith, give the Harris County Public Defender's Office permission to represent me, in the bail hearing if I am not present. And I have them sign it and date it.
I've never had a judge have a problem with that. Have you?
No.
Yeah.
But they don't let us generally if we haven't affirmatively spoken to the person and have gotten their permission.
That's good to know. I mean, like, I don't do it that often, but I find that the most difficult in that I feel powerless to help this person who, is seriously sick, or I think he is, and nobody wants to do anything.
One last thing is that sometimes we really are in a big time crunch. Like, sometimes it is a big time crunch. And what I have found is that when I need to interview someone and I'm like, I just need to get through this interview because I have 20 other people and I have 20 minutes,
right.
whatever. And so, and it helps because we're kind of when we're in the interview room, where you're in kind of close proximity to someone. And so I'm literally interrupting them. Like, I'm like, how old are you? Whatever. And because they want to keep talking about their case or whatever it may be. And I literally just keep asking questions. I don't look up.
Right, you got to keep that roll going.
And I mean, it sounds rude. It sounds rude and horrible, but sometimes it's like, I need the information and we have no time, and I try to tell them, look, I'm not trying to be rude, but like, we have 20 minutes to docket and I have 20 other people I need to interview and I want to make sure I get all of you.
Yeah.
And so literally I don't look up and I just keep going. I just keep going. I just keep asking questions and I just keep like writing. And at some point they quit talking. They quit trying to talk and they realize, okay, she's not going to be listening to me. I'm just going to be quiet now.
And I tend to say things like, we just need to focus on preparing for your bail hearing. We have to focus on the bail, sir. I know, but we have to focus on this hearing. We're about to have it.
It is nice though when you have time.
Yes.
It makes it a totally different experience when you actually have time to speak to someone, to talk to them, to spend a few minutes to, look up their information. It is frustrating doing the bail hearings when you have that docket where you just had to speed through everyone. You didn't have time to get the summary, their affidavit, the report, and it's just, it makes it a totally different experience. And it makes me feel bad for the clients because it's no fault of theirs.
Right.
That we're in this situation.
They're getting a bad experience from it. So, and one thing that I have been doing lately is when we have that time crunch and I don't get to spend time with them and I don't get to give them my standard advice and whatnot, like, put that information in your speech, so like right before court starts and they're all in there and you're like, ladies and gentlemen, we're about to start. Let me tell you what to expect. This is what's going to happen. So then, and that's when I tell them, look, there's certain people, I'm not sure which ones you are, but if you have this kind of case, you may get no bonded today. Anybody who gets set at a bond that's higher than they can afford, you have the right to have your bail reviewed as soon as you get to your regular court. Do not waive your bail review. You need to make your regular judge set that bail or reduce the bail, give you a personal bond, whatever it is that needs to happen. I also tell them stuff like, if your bond gets set higher than you think you can afford, you need to call around to the bondsman. You need to shop. These are private businesses. People don't realize that. They think it's just, either I can pay the 10% or I can't. But no, you can call around, and some of them will take a lot less than 10%. Because I talked to a guy the other day that had a $50,000 bond. He put $800 down and was able to get out. And people are like, oh my gosh, really? Like, and that gives hope. That right there. And they're like, oh, let me have that list of all the bondsman's numbers. Because I've had dockets where I've passed out. We have this list of all of the phone numbers for the bondsman, and some of them will take calls from jail, apparently. So I'll hand that out to, like, every single person there. And they're like, feeling really good about it. Even though I didn't get to spend a lot of time with each one of them, you can put information into that group speech that they're appreciative of.
Knowledge is power. I've never worked with you, Jani. I don't think I've ever done a bail hearing, with you. Do you do you know what speech we're talking about, or have you ever given it?
I do. Since I don't do it full time, I usually let whoever has done it more frequently give the speech. Like Shirlene is great at the speech.
Yeah.
But yeah, I give a speech if it's me, and I sort of do a general thing, basically what you're saying. But I think the most important thing, and maybe we should end on this, and I think Sarah should explain the shush factor. Go ahead.
Right. So, so a lot of the struggle
The biggest struggle.
Possibly the biggest struggle is keeping folks from needing to talk about the facts of their case. And so you have to tell them over and over again that, today is not about the facts of your case. All right. Yeah. So it's like, all right, so in a minute, the judge is going to come in here and the prosecutor is going to be on the screen behind them. They're going to call each one of you up individually. And the first thing that's going to happen is the prosecutor is going to read a summary of whatever the police had to say about your case. I know that we are not going to agree with everything that the police had to say about your case, but today we are just going to be listening for notification purposes. In this court, we're not going to be able to argue about the facts, and you are going to be on video camera while you're standing up here. So today, we just need to keep calm and just listen and be notified about the facts and not say anything. Because what I don't want to happen to you, and this is just for your own protection, what we don't want to have happen is, if you are standing up here, and it can be very upsetting when you hear what the police say. But if you act all upset and you say a bunch of stuff and you're shaking your head, then later on the prosecutor is going to pull up that video and show it to the judge or show it to the jury and say, oh, look at Mr. So-and-so. He's got an anger problem or something like that. But we don't want to give them anything to talk about today. Just want to be calm and professional and not say anything. And so, like, a lot of the time when you're standing up there, you'll see them start to talk or start to want to say something. And so you'll have to, I will turn my back to the camera and go like this. With different people, you write notes, right?
I write notes when I stand up next to them, like when the summary is being read out. And like I said, I always try to tell them, when I'm interviewing them, and then in the speech at the beginning, right before the docket starts, about what probable cause means and why we don't want them to say anything and whatever. But you do understand someone's natural inclination to want to defend themselves, right? They want to defend themselves, but I always remind them, these proceedings are recorded. It's a video recording, an audio recording. The prosecutor's there. Anything you say can be used against you. But when I'm standing up there next to them, when the information is being read out, you can feel it. You can feel it in their body. Like, you can feel them. And I'm like, be quiet. Stop talking. Don't, poker face. I'm like writing poker face. Like, so if anyone sees any PSAs that I do, you'll see all kinds of notes on there, and then I have to scratch it all out. But one thing I do is I tell a story if I get a chance, and it kind of helps them all understand, because obviously we don't want them to incriminate themselves. And many times they don't realize that when they're trying to defend themselves, they're actually making a statement that's harmful to their case, right? Because they don't understand the law or whatever, And so I tell this story where individual was charged with burglary of a habitation. And this is when the prosecutor was still in the courtroom with us. And the prosecutor was reading out, the summary to the hearing officer. And the hearing officer and I were both kind of looking at each other because it sounded odd. It didn't really make sense. And basically what it seemed like is that basically it's two guys, like older gentlemen who have like a history with each other and kept doing things back and forth to each other type of thing, right? And so when the prosecutor was finished, the hearing officer kept asking the prosecutor questions. Well, what about this? And does it say this? And, well, where was this part? Lots of questions. And I could tell that the hearing officer was really on the fence about this burglary habitation. And so I'm standing up next to the individual, and I could feel it. I could feel his body, like he just wanted to, I could feel it. And I'm like writing note after note after note after, don't talk, please don't talk. Please don't talk, whatever. Don't talk. I'm like, sometimes I'll hold my clipboard up and I'm like, quit talking, or like whatever. And finally, he just couldn't hold it anymore. He just couldn't hold it in, and he blurts out, "That's not what happened." He was like, "I just knocked on his door," right? And so the hearing officer turns to him and says, "And based on that, I find probable cause." And when I tell this story, like, they all start laughing, and I'm like, "Why do you think the hearing officer found probable cause?" And someone will always say, "Well, like, because he admitted he was there." Right. You know, she was having a lot of trouble with it, but he admitted he was there, you know, at the guy's house. And so that's why we tell them, like, please don't talk. And I saw one of our coworkers, literally get in front of the person and, like, cover them up, because like put their hands up, you know. And so, like, but they had their back to the camera because they were able to cover the person's face, and they're holding their hands up, like, you know, we've all gone to, like, some extremes, and we, you know, to get them to quit talking. And we were like, this is for you. It's not for us. It's for you. And I think that sometimes our biggest accomplishment is keeping someone from talking, because they don't realize how much it can hurt their case.
All right, one final question of each of you. Is there any one thing that you would say to people, you know, a final bit of advice that we didn't go over today that you would like our audience to know about bail hearings?
I will say this. I never, when I was in private practice, I never did any bail hearings. I never paid attention to probable cause court. I was very fortunate in that I never had a prosecutor come to me and say, "Hey, guess what your client said during, you know, PC court." I was very lucky. I'm sure they probably could have, and I don't think a lot of prosecutors paid attention to it either. But on hindsight, I wish I had. And I think that attorneys should definitely understand what happens in probable cause court. And I think that, you know, our hearings, they're public records. In fact, they can watch them, right? From the civil courthouse. Can't they watch them while they're going on? I think so. But I think that
you can request them. You have to request them by email, I think, and they'll send you recordings.
But I do think that if people have an opportunity to represent one of their clients in a bail hearing, they should. And I think that it's worth pulling up your client's videos to see what happens during the bail hearing, because you might be surprised, like, the information that you find out. Whereas maybe, you know, the prosecutor had to call the officer to get additional information that, you know, that you just assumed was part of the original report. So that's what I would recommend. That would be my advice.
Mm-hmm. Sarah, anything?
You know, just as you do it, you'll come up with, and this is for, like, the public defenders, I guess. Like, as you go, you will come up with standard speeches and things that you tell them, and you will listen to what the other lawyers ask and what the other lawyers say to them, and you will pick things up from them. You'll listen to pretrial services and how they do their interviews, and you'll come up with some really good ideas and ways to talk to folks. I think it just becomes a lot easier once you have standard speeches. Like, you have standard things that you say. And like with when you're trying to keep somebody from talking about their case, you say, "Sir, it's too public in here. We really can't go into the facts of your case. We don't want anyone to overhear. While you're in here, you just need to take the position that you don't know anything about it. Don't talk about it on the phone because they're listening to your conversation. Don't talk about it to pretrial services. Don't talk about it to anybody in here because there's snitches in here." And, like, they tend to understand that. Like, a lot of them will just, "Oh, you're right. I'm just not going to say anything right now." And also, my goal is for you to be able to get out on bail right now so that you can get out in order to fight the facts of your case better once you get to court. Like, if we can do this bail thing today, you're going to be in a much better position to fight the facts of your case.
Knowledge is power. I think giving them information and giving them tips and helping them understand.
We bring humanity back to their situation just a little bit. You know, if we can listen to them at all, they feel so much better. I mean, it's, even if we can't get their bond set, just, like, respecting them and treating them like a person, I think, at least puts their case forward on a little bit of a good note.
What about you, Janie? Do you have any advice?
My advice to people would be to do it, even if it's not in your
Wheelhouse.
yeah, if it's not in your wheelhouse, to at least do it enough so you feel you understand the process. And I do believe what you were saying earlier, and both of you, that there is a reward for it. And I love to talk to people. I love stories. And so that's the joy I get out of it. Like, I get to be a part of their story for a brief minute and share it. And so I would recommend everyone do it at least a little bit. Maybe not overnight, but at least a little bit. All right. Thank you.
Thank you.